The 32 National Unity Platform supporters have appeared at the General Court Martial in Makindye before Chairman Brigadier General Freeman Robert Mugabe to proceed with a case of unlawful possession of firearms against them. Although the case was set for hearing, this was impossible when prosecution asked court to allow them to amend the charge sheet by adding one count of treason. The prayer was, however, objected by defense, saying one of the accused, Muganza Joseph, was not in.
This amendment is defective even by its nature, because the essence of a charge sheet, it should be able to guide both the defense team and the accused person and give them an idea of the charge against you. Bringing a charge just for purposes of holding these people further, as the particulars read, there is no element, the summary, there's no element of the foreign power that these people purported to have supported, or any other force, or any element of infiltration of the defense forces. It's our submission, Mr. Chairman and Court, that this charge on its face is defective. That's why I was early advising them to make a formal application such that they can put that house in order. It's defective, and we pray that these people don't go ahead to take plea, or in the alternative, court makes a ruling on the same, because the particulars as read, which we have not been, unfortunately, had the cuts of serving onto us, don't make out a proper charge under Section 129.
The defense's prayer was overruled by Chairman Brigadier General Freeman Robert Mugabe, who later read the charges of treason against the accused. After court lawyer for the accused, George Musi, raised an objection basing his submissions under Section 129 of the Constitution, saying the charges are wrongly brought against the accused.
That the particulars didn't bring out the intended particulars as it is captured under the law, because to sustain such a charge, the person may have committed those alleged warlike activities, either being sponsored by a foreign force, or when he's part of UPDF, or he's part of another force. So the particulars read to us did not disclose that which said force that these people were part of. So we objected that the charges were defective and these people should not go ahead to take plea, which was sustained. The court gave them 2 weeks and adjourned the matter up to the 17th. We don't know what will happen on the 17th, whether they'll bring another charge or a third one, or even bring a witness. But our duty is to do everything under the law to ensure that these people get freedom, and that is what we shall never tire. So we think it's a continued use of the law to persecute these people.
The prayers were objected to by the prosecution, led by Lieutenant Colonel Raphael Mugisha. Judge Advocate Colonel Richard Tukachungura directed the prosecution to make its reply on the defense's prayers come 17th April 2023. In another development, Nayebale Sylvia has been confirmed as a duly elected woman member of Parliament for Gomba District by Mpigi High Court. This followed the court's dismissal of NUP's Senator Mobeti's election petition that was filed against Nayebale Sylvia. Judge Ajiji Alex dismissed this petition on grounds that the petitioner failed to present to court certified DRA forms as required by a court in any election petition.
Chasing of the petitioner's agents from 7 polling stations, namely Rwaweba Church of Uganda, Nachitembe Church of Uganda, falling under Chai polling sub-county, allegations of bribery of voters at Buinza, Butore, Kunyamwima village, and allegations of intimidation of voters and use of dangerous weapons at MAD headquarters 8M, Sozibiri A polling station, and Chamkam polling station. I therefore find that the above allegations cannot be sustained in relation to non-compliance, since the attached annexed DRA forms have been expunged, which leaves the petition with no backbone and therefore lifeless. There is therefore no evidence to support all the allegations set out above by the petitioner, and so this issue fails.
Court also said that the petitioner Sentam failed to prove electoral offences that were allegedly committed by Nayebale Sylvia.
Having found that the petitioner failed to prove that the election was not conducted in accordance with the provisions of the Constitution of the Republic of Uganda, 1995, the electoral laws in Uganda as alleged. She failed to prove that there were electoral offenses and illegal acts committed by the second respondent, his agents, and illegal acts committed by the second respondent, his agents, with his knowledge, consent, or approval. The petitioner therefore failed to prove her allegations against the respondents. The first trial court at the High Court in PG found that the petitioner had collapsed on a preliminary objection on account of non-payment of the full requisite fees. The Honorable Trial Judge declined to award costs.
Nayebale Sylvia, who was happy with the court's decision, promised to serve her voters.
It has been an appeal for all of us, but I'm thankful to God for this achievement. I thank my lawyers who have had sleepless nights to make this happen. I thank the people of Gomba who voted me in the first place, and I won overwhelmingly. I thank everyone who has contributed to this win. For the people of Gomba and the country at large, it is time for us to deliver service. We have had this time of more or less like a recess. I would call it a recess in service delivery, because we've been back and forth in court. Now that I have won, we expect the best, especially in the area of service delivery. Oh well, my message to the opponent, to my opponent, my sister, I know it's a bitter pill to swallow, but I call her upon and her whole entire team to come and we work. We work, because I believe what she has been fighting for is to get the best for the people. Let her bring in her efforts, her ideas that she has in mind. She can add them to my brilliant ideas, and we deliver service to the people.
NUP's Betty Sentamwani is lawyer who vowed to appeal against the court's decision after court addressed the media.
In various court decisions of the Court of Appeal, which is the last appellate court in electoral matters, that if you wrote to Electoral Commission requesting for certified documents and they have not availed you that opportunity to give you those documents, you can as well rely on the documents that were availed to you at the various polling stations. It is on record, and it is within. The judge also acknowledges the fact that the petitioner requested for those certified documents. Never is it on record, either by documentary proof, that those documents were availed to us. On that account, the judge has expunged the evidence that was tendered in court by the petitioner and consequently has dismissed the petition.
I'm a strong woman, and I've always told people that it's not over until it is over. Whatever we have seen, we have heard in the court, that does not limit me from moving forward. I'm going to sit with my lawyers. And we shall give you what we are going to do ahead. But all in all, I must appeal. All in all, I must appeal, because it is not over until it is over.